Hey everybody, welcome to the Cathleen Scott podcast. Today I am joined by a team of expert labor and employment attorneys at the Scott Law Team. I'm really excited about today's episode. It is jam-packed with some of my favorite topics. We're going to talk about remote working, kind of the do's, the don'ts, the pros, the cons, how to gauge productivity in the remote work world. We're also going to talk about what the heck is happening in the media and give you some suggestions on how to handle tribal workplaces. We're also going to close out the episode with things on restrictive covenants, non-competes, and non-solicitation agreements. So let's dive right in. The only time you'd have breaking news, you could only watch news. Let me start there. 6 o'clock, come on the TV set. Yeah. It would last an hour. That was it. And it'd come on again, often the same, anything new at 11 p.m. That was the 2-time 1-hour slots that you got news. If there was breaking news, they'd be like, this is Tom Brokaw.
Right.
Sorry to interrupt your programming.
Yeah.
But then the Gore thing happened with the election, and it became
the 24-hour news cycle.
That's
when cable was like a brand new thing.
Yeah.
Cable news, like CNN and Fox News had just started.
Yes, CNN did have 24-hour availability, but it was mostly C-SPAN, which is just basically a camera on Congress, right? It wasn't like it is now. It was, and it was always single person reporting. It was not like groups of talking heads filling space and telling you how to feel about things, and talking about like, oh, I'm bringing in an expert to talk about counterterrorism or whatever the fuck it was.
But I miss Crossfire. Like, we need that. Do you know about Crossfire?
Yeah.
Well, I was gonna say because Slate just did like a podcast, like a narrative podcast series about the rise of Fox News, and a lot of it dealt with like that exact time period as far as like because Fox News was a thing in like 96 is when like the Fox broadcast channel launches and they're doing this news station, and so
no one was watching Fox during the Al Gore election.
Well, that was their first that's when they Fox became big was the Al Gore election because the Bush election was because of what you're saying where they like leaned into like, oh, we can become like the station that is all of this. And Crossfire was on Fox News. Crossfire was on.
Why am I blanking on the guy's name from Crossfire?
The Raging Cajun.
I love him.
James Carville.
Yeah.
No. But after, I'm talking about the other guy.
No, Crossfire was
not with Wolf Blitzer.
No,
Chris Matthews.
Yes. He was the host after, and he is like I love that.
Yeah.
He's a fillet of fish. Are we starting? Are we already started? We're rolling. Okay, sorry. So anyway, the news cycle. Has become like a thing where like people, I have said this before, where it feels like, you would say, oh, seeing is believing, right? Like if you see something, you believe it. But it's like the news cycle is so flipped on its head with so much inundation. It's like now someone has to believe it in order to see it. It's like reverse. It's like if I told you that, you can believe that the earth is flat. If I show you a picture from outer space, you just be like, no, that's a conspiracy. Like it's like a.
So the thing about like the non-competes is there was this huge uproar about how the FTC came out with the non-compete thing, and they were going to be overturned, and they couldn't have them anymore after September of 2024. And then what happened? It quietly died, right? And so now people still think they don't have non-compete, so they're out there in the space going out and trying to get another job, not knowing that they're still enforceable.
Right, so we should be clear. Non-competes are enforceable. Right. You may have defenses to the enforcement. There might be issues with the enforcement, but as a general concept, they are currently enforceable.
Right, and this gets, to push back a little on like the news component, right? Because you were saying earlier how it used to be news was 6 p.m., 11 p.m., and then whatever Tom Brokaw told you, that was the news, right? And I think
not that was perfect.
Right. It's like we definitely right now we've gone too far in like the 24-hour cable news. Everything is breaking news, and it's not always breaking news. But I do think it's helpful when people have more access to information and we have the ability to know more things. We're talking about non-competes, right? Because the only news was when the FTC announced the rule in July that come September, these are going to be outlawed. And then there was no news coverage really of the opinion out of Texas that said, actually, no, that's not going to go into effect. And so, this gets into the idea of we do sometimes need more news because there was not media coverage of what actually happened in practice. And so you get a lot of people that reach out and say, oh yeah, no, I saw my non-compete is not enforceable, so I'm good, right? And it's like, no, we should really respond to the cease and desist letter.
Or why did I get a cease and desist letter when this isn't enforceable?
Exactly.
Yeah.
I think news that actually is helpful to people's lives, that tells them and gives them the tools and the information for them to make better decisions, like should I take this job that competes with my last job? Definitely. But what I worry about is the soundbite generation, which is like the only thing you hear is it's like little blip and you're like, you assume that that's gospel. You don't understand where it came from. You like don't challenge that. You don't really like dive into the details of it. You know, like there's some reporters who do a great job. Like there's a lot people who are out there like actually report the story. You know, we'll give you the link to like the actual article to detail, to back up to information. And then there's like entertainment, which is scary.
But it's dangerous too. I mean, how many times have like we've been interviewed by someone like a reporter from the news, right? And you sit down,
yes, exactly.
You do a 30-minute interview, you answer all their questions, you go through all this in-depth stuff, and then you go and find the report later, and it's like, oh, there's 5 seconds of me saying one thing.
Board-certified lawyer Kathleen Scott says non-competes might not be enforceable in the future. It's like, I said so much more than that, but
Well, I think that's something hard, like as lawyers too, that, you know, our whole job is in the nuance, in the details. So it's really frustrating, whereas like news people, you know, they're just trying to get as many eyes as possible, or clips, or even just talking to lay people. I mean, it's a stereotype because it's true, but so many times I get a question and I do have to go, well, it depends. It depends on a couple things. And I think that's hard for non-lawyers to sometimes.
Where do you see the future, though? Like for Anne's question, and we're using the word restrictive covenant. We should be clear that includes non-competes, confidentiality agreements, non-solicitation, no hire. I think what you were calling it earlier, no poach agreements, which is similar.
Trap agreements, training, repayment provisions.
NDAs, same kind of jargon. So all of those. Let's just go around the table. Like I don't know. What do you see?
I think there's enough bipartisan attention to where things are going to be changed. Where, you know, the issue with the FTC rule is that it was just a blanket without restrictions. These are all banned, right?
Right.
And that's just inherently going to get pushback from people. I do think there are nuances where whether it's sort of a increase in enforcement, right? If you look at Florida's statute for non-competes, if you just read the statute without context, it's actually a pretty fair balance of what we should be doing. Of these things are inherently illegal because they violate Florida's constitution. That being said, if you as an employer can plead and prove that you have a legitimate reason for them, okay, we'll allow you to go around the Constitution and still have these. The issue is it's, you know, sort of interpreted as, well, they signed a contract and the contract said this, and so therefore they're screwed. And so I could see that there's either more attention on enforcement, whether it's through agencies, whether it's state or federal agencies, spending more time when companies are trying to enforce on, you know, illegal agreements that are going outside the statute.
Okay.
Or other things like, you know, in Florida there was that, you know, they tried to pass that bill that would have made it so just for medical doctors, you know, they're excluded, right? It could be more position by position. There's
like
more
lawyers
nuance.
who obviously know how to lobby. I don't know.
Well, and that's the thing is like it's gonna be who has the power, right? I mean, in that bill that in Florida that was sponsored that would have excluded medical doctors and only medical doctors, just to be clear, from the non-competes. The representative who sponsored it, he was a doctor, right? So of course he had his own personal interests of, I don't want me and my buddies to be stuck at a hospital.
So Gabe Roberts, he says it now. Future of non-competes is going to be focused on enforcement, but still going to exist probably in some capacity.
Yeah, there won't ever be an outright ban, at least in Florida, I don't think. I mean, if it would take a dramatic change in our state's politics. There won't ever be an outright ban, but maybe there'll be more attention on enforcement.
What say you?
Well, my issue is the presumption of harm that shifts the burden to the employee who is, you know, probably out of a job right now because nobody
can't afford a lawyer.
Up against this big company. You know, I have a problem with that. I think that you know, there should be some mechanism where they first have to prove before they can get the injunction. The employer should have to prove the legitimate business interest first, and there should be a preliminary hearing.
Like not just as like a checklist, like yes, they pled it, like but actually have like some proof
because there's a presumption of harm, and that presumption is very hard to overcome to a individual as opposed to a big company. But I think that there are legitimate reasons to have non-competes. I think if your whole, you know, you are a startup, say, there are certain tech jobs and tech industries where you're a salesperson, you have access to all the company information that puts you head and shoulders above any other competitive person who you're working with in sales at the new company, right? Because you have the inside scoop on pricing.
Right. So some relief, sort of some protection is...
some protection. Absolutely. You should be able to train on special ways to sell, special, you know, what sets you apart from the other companies. So yes, but you can do those things with confidentiality agreements. You know, you can do those things with other mechanisms that don't stop people from being able to go and get another job.
I like what you said about judges. Like they should actually do their job and like actually like require evidence and proof that supports, you know, before they just willy-nilly willy-nilly until they just agree to enforce these things.
But sometimes it's a judicial education issue, which is as much on us as lawyers, right? Our job when you're arguing something to a court is...
They don't see these every day.
Yeah, right? I mean, if you're dealing with a regular circuit court judge, maybe they were an employment lawyer before taking the bench, but they could have come from family law. They could have
More
been...
likely not, yeah.
Yeah, they could have been from anywhere, right?
Yeah.
They could have been a criminal defense attorney who got elected and all of that. And so it's on us as much as it is, the judicial college and other places to have more education in place so that they know, like, okay, if let's say somebody moves for a temporary injunction, I'm going to hold an evidentiary hearing. What should I be looking for, and what do I need to know as a judge in order to like decide?
Yeah.
All right, is this a situation where this person has access to a lot of very specific information, and if they're allowed to go and compete, that's going to harm my business interests versus this is just Joe Schmo employee. You can't stop them.
Right.
So we're going to dip our toe into this kind of like scary thing, but the Federalist Society is kind of known to be putting forth judges, right? And they tend to be very business oriented. So, and if you're working for a company that's an interstate company, maybe those companies have, that they can get us into federal court or get the employee into federal court, and that there's a difference between state judges that have to get reelected and federal judges who get appointed.
It's interesting because, it would seem logical to me that if you're a pro-business judge or a pro-business person, that necessarily would make you not pro-non-compete. Like, I want to make that argument because, in a way, you can't attract the best talent. You can't encourage change. You can't get competition. You can't get the best employees or people or whatnot if you're going to be everyone's going to be stuck with these restrictive covenants. And so if you want to be about competition in the marketplace, you should be a great place to work. People should want to come for you. You shouldn't have to knock them down with these like do or die things. But obviously I know that's not the world we live in, but I do think it's an interesting observation to say that, like, if you're going to be a conservative, which we typically would align, the politics of pro-business with a conservative mindset or a conservative bend, conservatism would say the market controls, right? Like, it's a free market.
Marketplace of ideas,
exactly.
pro-competition,
right.
pro-capitalism, all that should be anti-non-compete.
I mean, it's
But
communist
that's
to basically...
That's
not reality.
The current
I just
status
think it's
of
worse.
conservatism.
It deserves air. It does deserve to say out loud.
I will say, I think that I don't, maybe because I edit this out, but maybe because I do like some more employer side work, but I don't have as much of an issue with non-competes. I think they're a really useful tool, and restrictive covenants in general, if they're crafted very carefully and very narrowly. I do see employers come in with just sort of like they downloaded a non-compete.
Yeah.
And the restrictions are crazy. And you're sort of shooting yourself in the foot if you have your employees sign a completely unenforceable agreement, right?
You have one where it was like the whole United States or the whole world?
Yeah, it was the whole United States.
The company was like they got the whole world in their hands.
Yeah, exactly. Things like that. And I really feel for the client in that sense, because I mean that's unenforceable.
Well, they have to move to Spain.
Yeah.
But I have a problem if you're graduating from college and you're desperate to get a new job before your student loans kick in, and you can't, you have no choice but to sign a non-compete because everybody in the space requires people to sign a non-compete. And then you can't, they know that they've got you locked in because you can't move to another job and make more money.
I think that's what I'm saying is I don't think there's an issue with restrictive covenants like wholesale. I think that they've become too prevalent, and like we were talking about the Jimmy John's case, right? Like that's not a good candidate.
You're a sandwich artist. You can't work anywhere else.
Well, that's why it comes down to enforcement.
Subway's calling, but you can't go.
I was going to say Subway sandwich artists who might be in trouble for that one. But no, it's like, so I had these clients who are great clients who they originally came to us because they were subject to their own non-competes, right? They worked for a company, and the company had them sign these ridiculously overly broad non-competes, and they wanted to go out and do their own thing and help them. We helped them get out of those non-competes, right? And so then they went and opened their own business, doing something similar, but it was not competitive. It was not within the geographic area and all that. But they opened their own business, and they were like, okay, well, we still want some protections for our business, right? We've opened a new business now,
Yeah.
but instead of, doing, what's been done unto me, I'll do unto others. Instead, they called back and said, hey, we have our own business now and we want protections, but also we don't want to do to our employees what was done to us. Like, can you help me narrowly tailor agreements that are actually specific to what we're looking for, right? And that's what you're saying, right?
Yeah, I love that.
There are situations where non-competes or restrictive covenants and
Yeah.
non-solicits, whatever they are, they have a lot of value. But it needs to be, you're doing it intentionally because it's, hey, we operate a dance studio that does a very particular type of dance, and we don't want the people that we teach to be trainers of that type of dance to go across the street and steal our students.
Right.
If they want to go across the street and do tap dancing, we don't care. That's not what we do.
I'm sorry. There was a really cool part of the FTC ruling where it talked about how you can't use a non-solicitation by one person that one person signed to basically become a de facto non-compete for other employees who never signed a non-compete. And I think that's really interesting too and really cool.
And I think we should say for employees to understand, one is like there's a non-solicit, right? Meaning don't solicit customers, don't take business directly. And the other is you can't work competitively at all. Like, and maybe to your point, like an employer can get what they need with just a non-solicit. Like, okay, we'll leave your clients alone, but you can actually go work competitively, but you will leave your clients alone.
You won't work with any of our clients for the next year.
Right.
Or like a non-disclosure or confidentiality agreement. I mean, or even just like, Florida, like most states, has the Uniform Trade Secrets Act. Like, there's, even without a contract in place, there's a statutory provision that says you can't go use trade secrets.
Right.
And the duty of loyalty.
Right. If you're devising the new Coke recipe,
Yeah.
you can't go.
I do think there is something to say though that what Kathleen was saying about you would think that people who are pro-business were like would be pro non-compete,
Yes,
right? That they
yes,
would want
yes.
an open marketplace. But what I see sometimes with non-competes is that it's not necessarily about being anti-business or bad for business. You just don't want people to have an unfair edge.
Yeah.
Mm-hmm.
That I do think there is something to say that if they're crafted carefully, which I'll say over and over, like it's all about the nuance and the details. And that's
Yes.
why you need an actually good non-compete, not just when you download it. But that it can be pro-business. Absolutely.
It can be.
Especially in a state like Florida where Florida has a privilege to compete. Like there's actually within our common law, there's a privilege to compete in Florida. Our Constitution is we're a right to work state, right? There's a right to work in our Constitution, meaning that to have a non-compete goes against all those things, and so you should have a legitimate reason. You should be able to craft it.
It should be strict scrutiny. I mean, it's
I
a
like the
constitution.
FTC's sliding scale about the salary too. I thought that was an interesting study that they did to say that there are particularly adversely affecting women who have kids because they don't want to take the risk of being sued because they don't have the budget to defend themselves, taking lower paid jobs and kind of being stuck. And I like the idea that they had in there of having a certain, I don't recall the income threshold, but I feel like it was like
151, I think.
Yeah, 151. That made some sense to me.
Yeah.
Although in your dance school example, that wouldn't work because it's like, but you could probably accomplish that with just a non-solicit.
Yeah, same thing, non-solicit, or if I teach you specifically how to teach this type of dance, now that's some sort of non-disclosure confidentiality thing.
I really think that you need to consult with an attorney though if you're trying to get out of your non-compete, because there are
Before you leave.
and I know that seems self-serving, but the reality is we've helped a lot of people get out of their non-competes. We've helped a lot of businesses enforce their non-competes when they're, and we've been able to help people narrow those things after the fact when they've been, to make everybody happy to a certain extent.
Yeah, and it's probably like some best practices would be helpful, right? Like I think when you're representing the employer, I've never understood why employers don't give a copy and make sure people get what they signed regularly and then have them sign it every couple of years because circumstances change, jobs change names, people change positions, and that could be an issue for enforcement, right? So make sure you're having updated agreements, but make sure people understand what it is they're signing. I think there's sort of this like secret culture of an employer being like, oh, sign your W-4, your W-2 form, and like, here's the employee handbook, which people aren't reading. Oh, and by the way, here's your arbitration agreement, and please sign this restrictive covenant that says you can't work for 2 years anywhere other than here, and so it's being snuck in at the last minute.
But if you want to enforce it against them, like let them know about it. Or even if you sneak it in at hiring or as part of all the documents at hiring, if you're ending somebody's employment, there's no reason to, as part of a termination letter or having them sign any offboarding documents, or maybe when you send them their 1099 W-2 at the end of the year, just send that too, because if you want them to follow it all you're doing by not sending it to them is taking the risk. They're not going to follow it.
How many times has an employee said to you, "Oh, but they fired me, so this isn't enforceable anymore"?
Right.
Yeah.
Or I get people come all the time like, I think I signed something.
I signed something.
I don't remember what I
I
signed.
asked for it, they won't give it
They
to
won't give
me.
me a copy of it.
I cannot understand
I don't
that.
understand. Yeah, it's like as an employer, all you're doing is hurting yourself by not
Make
giving
it
it to
seem like
them.
it's something wrong if you're not going to produce it. It should
Right.
just be out in the open. We use
also-
the word transparent. But
Yeah, and also this is something for employers, and I'll look directly into camera and speak to employers when I say this. If you're,
Breaking the fourth wall.
I know, if you're going to go after an employee for a non-compete, please hire an employment attorney. It doesn't have to be the
Yes.
Scott law team, but please hire an attorney who knows employment law, because the amount of people who will come to us for consultations who they've received a cease and desist letter from their former employer, and the cease and desist letter was written by some random attorney the company hired who doesn't do employment law, and we're reading through these letters and it's like,
please govern yourself accordingly.
Right. But it's like, but nothing in there is actually what the law is, and it's just like it's like going through first year law school contract principles, and they're not analyzing the Florida statutes. They're not
Or they
looking
don't
through any of
attach
that.
the
They don't attach the
alleged
agreement,
non-compete.
and it's all these things. And then we get these letters, and it's just like we have to send an angry response to cease and desist and say, hey, I understand this person signed a contract, but you
Right.
understand like your client needs to do X, Y, and Z, blah blah
Yeah,
blah.
now you're teaching them how to behave.
And depending on the ego of the attorney on the other side, sometimes they say, thank you so much, I didn't know that. More often than not, because of who our profession is, it just turns into suddenly
vinegar,
you're on a bad footing from day one. And so there's also just this, I don't know, this kind of negative start to these cases that can happen when the attorneys on either side, whether you represent the employee or the employer, they don't know.
What do we tell? I mean, I tell employees, like before they sign, ask questions, understand, try to bargain for more. Get your coworkers to bargain. We love that, right? When they get more than one employee to bargain together.
I had an interesting case that a guy actually said, I'm not signing a non-compete, and then he quit his job based on this offer. And when he sat down to do his new hire paperwork, they said, and here's your non-compete. And he had already quit his job in reliance on this new job and in reliance on their representations. And, the answer is don't sign it or you will have a non-compete regardless of what they told you.
Yeah.
That's a good point, because it's, to go back to first year contract principles, it's also that whatever you say outside of the contract, that doesn't really matter.
Right,
If
so
the
get it
terms-
in writing.
Yeah, exactly. So it's one thing for your employer to say, here's a non-compete, and you say, okay, but like hypothetically, if I leave in 2 years to go do this, and if the hiring manager says to you, yeah, that's totally fine, whatever, that's not enforceable. Please.
So employees should be asking for a copy of the restrictions
Yeah.
during the interview process.
Anything that they sign
Yeah.
or
Like,
anything
can I get
that
a
they're going to be
copy?
asked to sign.
Yeah.
Right,
They need to get copies of it.
And if they're going to agree to give you something about, no, of course you can go and do this or whatever, don't sign an agreement that doesn't include that change.
Right.
And if you're a job hopper, if you know that your business is premised upon changing jobs every year or every 2 years in order to stay ahead of the curve, from a economic standpoint, then you absolutely should be, getting copies of those contracts and bringing them into an attorney to look at and tell you what's enforceable or how you might be able to change them, because we all know every single one of them says you should consult an attorney, but hardly anyone does.
It doesn't just say you should consult an attorney.
that you have.
It says by signing this, you acknowledge that you had the opportunity to and
Yeah.
did consult an attorney.
Yeah. So
you have to level the playing field. I think you do need to get it looked at and not be afraid to ask, can we reduce the time period to,
Absolutely.
6 months or a year?
Yeah.
Or I think asking for pay, like I think, because here's the
Yes.
problem. Like when you're in the
Severance.
beginning, when you're in the beginning of the relationship, it's the honeymoon. You can't negotiate these things. You can, but it's harder to negotiate them at the end of the employment when everyone is mad at each other, right? It's so much easier at the very beginning to be like, hey, if you're going to fire me for like no reason and you want to enforce this restrictive covenant, you should pay that.
Yeah.
In the financial sector, we call that garden leave. It's very common. And it's the length of time of you sit out 6 months, they pay you 6 months.
Some states require, I think Massachusetts, that's part of their non-compete statute, is if you're going to enforce it, you have to pay the person for that time period.
Yeah. So
But that's a way to level the playing field.
it really is. It really is.
What if you just have a high performer that is somebody who you have a new boss come in and they're just at odds with each other? We know how that is. Like somebody is
Personality dispute,
personality
doesn't work.
conflict, and all of a sudden that person's gone, but now they can't go work somewhere else, and through no fault of their own.
Right. And now they're stuck with this.
Now they're stuck with this non-compete and absolutely nothing to do about it, and they have to defend.
I would say, show me the non-compete.
Well,
I'll find
for
something to
sure.
do about
What
it.
did you
Yeah.
sign
There's
after
usually
it, and what was in that
what
contract?
happened to you during your employment? I mean, there's so much there to do, but you're right in general.
Yeah. I want to go back to, you mentioned the FTC, because there was that rule last year where the FTC had tried to invalidate non-competes, and it was outlawed, it was found illegal, right? So non-competes are still going to be enforceable, but I do think that's part of maybe a trend, especially, we're going into a new year, a new administration's coming in January, there's going to be some changes. And so that includes changes to the federal agencies, such as, the Federal Trade Commission. I think it's very unlikely that they're going to try to appeal that ruling and try to revive their rule, right?
Sure.
But there's also going to be other agencies that are going to be changing over, and that may have an impact on non-competes and other laws. So I'm curious, just going to the table, like Kathleen, what do you think is going to be the biggest thing that's going to be changing under the new administration for employers and employees?
So I think the National Labor Relations Board's rulings are probably the most vulnerable. And I've lived through many shifts. I've lived through you can't have confidentiality in the workplace. You do have privacy in the workplace. You don't, you do, you don't, you do. So I think that's probably, those things always shift. I think the shift now is going to be pretty clearly in the direction of a pro-employer shift. So I worry for employees that right now we have a little bit of a momentum behind the idea that employees, when they settle their cases or they have a severance agreement, there's preclusions against them, like signing these non-disparagement clauses or these huge releases that are so overbroad and things that relate to confidentiality. I think that's probably not going to be the case anymore, right? I worry for that. For that. And I don't know what's going to happen with the Department of Labor and the idea that I've heard these ramblings of tips are not going to be wages anymore, which is going to make it very complicated for an employer to figure out how do I pay an employee overtime? How's that going to look? What does that look like? What's the amount? And so I think there's going to be a lot of questions.
Yeah, there's going to be a reliance interest on a lot of the stuff, like tips and things that were not new rules during the Biden administration, right? Things that have been like counting tips as wages, things that companies have kind of taken it for granted for years.
Right.
If there are dramatic shifts there, that may help employers, but also may just make.
But let me just say an example. Right now, if you're a tipped employee, the employer doesn't have to pay you the full wage if you receive a certain amount of dollars in tips. If tips are no longer wages, and an employer is not tracking those anymore, no one's ever going to fall into that as drafted currently tip category. So I think that's going to create a lot of confusion, which equals lawsuits, which equals more expense to the employer. That's the irony here. In an effort to be we're going to make these changes, but really what it's going to do is make compliance issues, and it's going to open the door for lawyers who are that sounds like a violation. You're going to get sued under the FLSA. And just to be clear, the FLSA is probably the easiest statute to bring a claim under. On behalf of an employee, you get back wages, double damages, plus attorney's fees and costs. So I worry for employers that sweeping change will create huge questions for compliance, because the law isn't going to, you can't change the law sweepingly, but you maybe could change some of the interpretations and some of the CFRs. So as an employer, I've been living by these principles, but now the definition of what wages are changes. How do I now fit into these exemptions? No one's going to know the answer.
And you've got to pay an attorney to try to give you their best guess and change your policies. And
there's going to be some confusion. And I think,
what do you think about these, business people donating huge sums of money to the administration and then coming in and becoming, in some ways like a shadow government, overseeing things like the Department of Government Efficiency and someone who has been outspokenly anti-union, outspokenly anti-remote work. What do you think about that and how that is going to impact the employee protections over the next?
The union issue is an interesting issue because it's becoming increasingly difficult for unions to organize. And there's recent Supreme Court precedent that says you used to be able to withdraw the dues, right, from I guess that's Florida precedent, from a employee's paycheck. That's a very easy way to get your union dues. That's no longer allowed. So now you have to actually pay the union like you pay your light bill. And that's one more thing for an employee has to pay. So it's
remember.
The attendance in unions or the interest in unions has dropped increasingly since then. So unions have always been kind of the backdrop for really bad employer practices, right? First, there's the market should control a bad employer, right? Because if it's not a good place to work, people don't want to be there. The second option is, maybe there's a law that protects employees. In Florida, we don't have that, right? And so then the backstop is, unions should step in and kind of help employees when it's really, really bad. And so I worry to your point, an anti-union administration, there's not, they can't do everything, right? Even at worst case scenario, there's still a huge, rich history in this country of union rights and the law. They can't undo the entire law without the support of Congress. There's a narrow majority. So I think we're right to be concerned. What I want to say is unions are going to be in jeopardy because they're already losing money and making it difficult to organize. That makes the larger unions, some of them are more scary than others, right? That they have more power because like Teamsters, they've been around a long time. They have all the money. So like that's like, so is it going to become monopolistic in terms of like how many unions are going to be able to exist in this new environment where it's hard to get money and it's hard to organize? So I think that's a legitimate concern.
So the funny, ironic thing is that it's actually been businesses who have been, and conservatives who have put out this idea that unions are bad, that have driven people from unions where the unions are what's actually going to help the employees, right? I find that a very interesting kind of dichotomy.
You all know that my husband's English. They have a phrase that I haven't heard here in the U.S. that he likes to say, it's like turkeys voting for Christmas, like when people vote against their own self-interest. So, yeah.
I like that saying. I'm going to definitely keep that.
Christmas. It's good.
Yeah.
But I think employees have power right now.
Yeah,
and I think they need to tap into that and recognize that, like
the remote work thing, right? Where it's like, yes, there's a pushback against remote workers right now. And so if you're a company that can host remote workers, can do remote work, like actually you have the power now to take advantage of that in the market.
Talent, the very
exactly.
best
You can
talent.
bring in the best people who, if you're willing to take remote workers.
it's like what they're saying, what you can say about AI. AI is scary. We don't know the future, but it's going to be the lawyer that works with AI that succeeds. It's the same with remote work. If you're a company and you can't embrace the principle of remote work, then you're going to be left behind because the world is moving in that direction. It's already there. Yeah. It's been there.
It's like WALL-E.
Like the movie?
The movie WALL-E. Yeah. I mean,
How?
You're going to sit in comfy chairs.
I've never seen WALL-E, so...
People were sitting next to each other, but rather than having conversations with each other, they would like talk through these computer screens, and they all sat in these moving chairs. And it's just it's kind of.
I think that's an argument for why remote work maybe isn't the best.
I was like,
but I think there are legitimate challenges.
We're connected with people. I mean, we have an employee right now who's able to be with her family in another country and still work for the whole month, and that you can't replicate that, if you don't allow. I mean,
also like the idea of just being able to like go outside and walk around with your dog for a few minutes, like during the workday, like that's healthy. But I understand employers' concerns. One is like, so there are people who feel like they need to see employees' faces and their butts in the chair. In their mind, that's what work is, right? And so I think for employers out there that are like they have like almost a philosophical view against remote work. I would challenge them to say like, maybe your metrics aren't in order, right? Like if you're looking at, if you need to see somebody's face or someone's butt in a chair to say that they're working, the problem is you. Like you need to set metrics. Like what's a good work week look like? What is that employee supposed to be doing? Like if you can't measure that, that's the issue. Like seeing is not productivity.
Yeah, you need performance indicators, right? If your only measurement of someone's success is they're in the office 8 to 5, that's actually that may not be success, right?
Like Office Space, where the guy's like, I don't know what I do. I don't do anything.
Like I remember I was in a job once, and it was an in-office job, and one of my coworkers, he was in the office. He was always the first one there, and he was usually the last one to leave, and he would sometimes work on the weekends, and upper management who were just, all they knew was the time of his badge swipes. They knew when he was getting there and leaving. Yeah. They thought he was the best employee on our floor. He was easily the worst person in our office because he was so inefficient. And the reason he was in the office so often is because he was terrible at his job and he was the most inefficient person we had. And it
But he was nice?
But he wasn't very nice. And it proved itself out because when he left that job because he wanted a pay raise and they didn't give him a pay raise and he left that job and went somewhere else, I think he's on his 4th or 5th job since he left that office because he went to other places that had remote work policies. Right. And they were judging it not just on when are you sitting at a computer. It's like, hey, what are you producing for us? And he was actually not producing anything.
Right.
Because just because you're in the office 10 hours a day or you're working 60, 70 hours, all that means is, it means you could be an inefficient, bad employee.
Yeah, so the question is, do you want productive employees or do you want to see their faces, I mean, that really is the question for an employer.
Right. Is your non-compete about controlling your staff and making sure they can't work for anybody else? Or is it about, I gave you specific information I don't want you using with my competitor?
Right. Well, I think then we should talk about, too, that employers should have policies if they are concerned about employees working, because that's one of the arguments.
Sure.
Employees are working 2 full-time jobs
Yes.
at the same
And
time.
it is true.
And that's a legitimate concern for employers, right?
Yeah.
They should be getting the value of the employee that the time that they're paying. So how do you fix that? Well, I think that you can have a policy that says that if someone is working elsewhere outside, you're not stopping them from working a second job, but you need to disclose that.
And you can figure it out with software. It's very easy. Like I would highly recommend that employers have their own computer being utilized. No more using your own device, because if you use the employer's computer, you can very easily see the productivity. You can see what they're doing during timestamps during the day. I mean, that's like usually how those things rear their head. So I think the big box items for challenges for remote work are like, one, security. Like there has to be security. So hard stop on if an employee has to use a personal device, limit that and make sure that you're monitoring it, because that can be really scary. An employee logs into your system that can cause like havoc, right? Sure. Other things, productivity, you can also solve that by just having the right equipment, right? And then when there's like the communication challenges, because it's not so easy when you don't see everybody every day. Like how do you maintain that teamwork kind of team building thing?
Morale, yeah.
Yeah. So I think there are things that you can do. I like what we do. We do the huddle. That works well. Seeing everyone's face every
awesome.
day
A
at
daily
noon.
meeting, 5-minute stand-up meeting.
Yeah. What
or
other
whatever.
things though? Like what do you think works?
That's different.
I just wanted to say the huddle, I think, is like such a great idea. I've worked at places that even though I was in office, everyone was so busy that, even though we were all there, it wasn't easy to
your
connect.
door's closed and you're like hidden in a corner. I know.
Yes.
That's what makes me laugh.
Yes, that, people are so busy. They don't have time to have those meetings. And the fact that the huddle is every day, I think it's the best idea.
Good.
Yeah.
Good.
I also love shameless plug for Bonusly.
I know, but I do think it works.
This is a non-sponsored post, but it is super fun, and it is so nice that, whenever I get points from a coworker, it can be for something small,
I got points from Gabe the other day for doing something. It was really nice.
I don't remember what it was, but okay.
Giving employees a chance to recognize their coworkers is empowering for the employees too.
Yeah.
Yeah, I mean, it's acknowledging that we
You
are.
should probably say it's an app that you can download that you can use to give recognition, and it's like a team building app.
Connects us. It
And
connects us,
And the
even though we're
points
not
turn into
together.
dollars where
Right,
employees
the
can
points
spend
be
them.
gift cards, gifts, presents.
Yeah.
It's like a reward system for your credit card or whatever.
It's the anti your presence is my present.
Yeah, but it's one of those things where like we are in a 21st century with technology and the ability to have remote workers, but also not just have remote workers you're doing the exact same thing you'd be doing in the office just at home. It's you also have to do things, to have meetings, to increase morale, to still kind of create that ability of, okay, it's still a workplace. I still have my friends. I mean, I haven't looked in a long time. I remember one time seeing there was this post about, where do people meet their significant others? Where do you meet your friends, right? And if you look over time, it was always like, okay, college, and then work, college, work, church, and nowadays everything is online, right?
Everything is online.
And so it's one of those where it's like, if we're not going to have systems in place where you don't meet your best friends at work, you meet your friends through online things, is okay, well, let's let work be more online as well and make it so people can still have friends and make friends at work.
An interesting idea.
Also, I think that for, in particular, women who have been and it doesn't have to be women, but historically it has been women who have been disproportionately affected by, being forced to a strict 9-to-5 schedule coming into the office, or 8-to-5 schedule. I think that you're going to open the door to a lot more talent, and not just talent in this country, but maybe you're opening the door to talent where someone lives across the country and it's 3 hours time difference, but that person might work better, earlier in the day to later.
Flexible work schedules.
Yeah, flexible work schedules. But I do think that it's important to get the team together when you have a remote workforce, because you do get a little disjointed and you lack the cohesiveness, but you also lack that connection to the job that gives some
you
people
just sit behind an email and like say something snippy because you don't have to have that face-to-face interaction,
Yeah, and I like the warm fuzzies of sitting in a room with all of you.
Yeah.
Nice. I do understand employers' concerns, though. I do. Sometimes it's like, oh, my child's sick, I'm going to work from home. It's like, well, if your child is sick and they're an infant, like,
Are you really going to be working?
Right. And so I think to your point about the policies, it is helpful to be like, either you're on or you're off. Like, I can't, like, in the middle, like, you kind of try to log in. It's like, no, just in or out. Like, that's really important, I think, with women. And then showing up with your screaming kid in the background is not cool, or, like, trying to do like, that's not that I don't understand. I love kids, but, I just.
But that comes down to just having metrics in place of how do I measure your
Yes.
productivity outside of the hours you're logged in, right?
Yeah.
And so it's one of those of, look, if your kid is sick, take the day, go home, deal with them. But also, like, if you're going to be working from home, I want to make, in fact, and I think you might have said this to me when I first started working here because I was working remotely, the expectation is almost higher when you're a remote employee because if people don't see your face, the assumption is you're not working, right? So you have to go kind of above and beyond as a remote employee to prove to them, hey, you're working, you're logged in, you're doing this. And so it's when you're a company and you're creating metrics, policies for remote working, you don't want to go to the extreme and have the metrics for remote workers be more than in-office workers.
Right.
But you still want to have metrics in place so you can know, okay, yeah, I didn't see Gabe's face today, but look,
It is true. Like there's a stereotype about it almost. Like, oh, he gets to work remote, so is he really working? Like, I think that's changing a little bit now, but even in the last few years, I think it's getting better. But
you hear people though who talk about how they work so much better and more efficiently at home because they're not constantly being interrupted.
And eat better too. I mean, for me personally, like I work out so much more because I work from home and I'm able to like stock my fridge with healthy food and then I eat and I'm not like ordering Uber Eats. I'm saving money and I'm like cooking healthy stuff. I think
and you're saving, hour and a day of commute, whatever it is.
The environment. You're saving the environment, the environmental impacts.
I do have groceries delivered, so not totally, but yes.
Right. And some of us have electric cars, so.
But I'm saying if we can talk about your lithium batteries going into the landfill. Okay. I'm just going to say it. But the truth is, like, if you're saving that time for that employee, the truth is that they are going to be more they're going to like you better. They're going to like the workplace better if they don't have to spend 2 hours commuting.
Yes.
If you're drawing them in, I think, to your point, if you're doing the team building things and you're doing the occasional, I feel like in our own practice, we did that NELA event. That was like I noticed a definite uptick after that in terms of employee.
There's a lot of camaraderie. I mean, I learned things about Anne I didn't know at all before
I'm sure. Every time.
I did not know Hannah was like a Green Party, she like ran for office.
I didn't know that.
I didn't know that. I still didn't know that, and I was there.
Well, no, that was from the holiday party last year. That was our trivia fact.
Oh, was it? Okay. Is that where I learned that? Okay.
Oh.
Yeah.
Yeah. Okay. I'm not anti-electric vehicles, by the way. I was just making a joke and picking on him. But
I do want to go back to something you mentioned. We were talking about what's going to happen in the new administration and agencies and all that, and you mentioned regulations, right?
Right.
Because I do think this is even beyond what's going to happen when a new administration comes in.
Right.
And, we'll get a new general counsel of the NLRB and the structure of the EEOC commissioners will become 3-2 Republican, Democrat, right? Those things will be important. Will have a big change. I think the biggest thing going into, and this might not even be just the next 4 years, who knows what's going to happen, is going to be that Loper Bright decision that overruled Chevron. And I think nobody really knows for sure what's going to happen.
Like what, and just to set the backtrack, what policy making authority do agencies even have anymore?
Yeah, so this goes back to, Chevron's a 1984, I think, decision where basically the Supreme Court came out and said, if Congress passes a statute, for example, the Fair Labor Standards Act, that says employees who work more than 40 hours a week should be paid overtime, but Congress isn't in the position to decide, okay, what does it mean for somebody to be exempt, non-exempt, meaning eligible for overtime, not eligible for overtime. So Congress, they give that power to the Department of Labor, which is a federal agency, and Department of Labor issues regulations that can change from time to time in a much more efficient and better process than
as the subject matter experts.
Yeah, as the subject matter experts, right? And the Chevron case in 84 says, okay, if a federal agency issues a regulation based upon power given to them by Congress, we as federal courts, we should defer to the federal regulation. That's been the law since the 80s.
And then COVID happened.
Well, and then 2024, the Supreme Court overrules Chevron.
But I think that was because of COVID.
I think they were, it had been going on for a few years.
It's like we always allowed the Department of Labor to regulate the workplace until they started telling us to wear a mask in the workplace.
Well, yeah, and that was the OSHA case too.
Well, that's what I'm saying. And that was like, to me, that was the beginning of the end here.
Yeah, I think there was an EPA case.
Okay,
West Virginia versus EPA was the first time you heard this thing called the major questions doctrine, where the Supreme Court was like, actually, we think when it's a major question that regulations should be given less deference. And everyone's like, what?
What does that mean?
What?
Yeah.
And then that kind of led its way to...
Right. We're going to agree to the agency that's the subject matter expert as long as we agree with what they're doing.
Yeah.
Which is essentially what happened.
Which is really kind of scary because that's kind of a mudding of the branches of government.
Yeah, it's separation of powers, right? Because Congress passes a law, and the law that Congress passes says we're going to give the power to the federal agency, who is a subject matter expert.
But that's the checks and balances. That's what we're going away from, and that's scary.
Yeah.
No one agency, no one branch should have
Right, and I think that's finish your point. You're saying so like the agencies now, so now powers in question,
right? Because now the most powerful branch is the judiciary. Because now with no Chevron, the federal judiciary, they get to decide whether they want to care about regulations or not, right? So you mentioned regulations earlier. Actually, I just had this happen. It wasn't definitive, but I was in a settlement conference on a case, and so it was a settlement conference, so I can't go into details. But it was an overtime claim, and part of our claim was that our client is non-exempt, meaning he should be given overtime pay, right? And under the current federal regulations, in my opinion, it was a pretty clear-cut case that our client was non-exempt because he did not meet the definitions, right? And we're in a settlement conference, and we're going through all that, and I'm explaining that to the judge, and the judge is like, look, I think you're right. I think you, on the regulations, have the right argument. But you have no way of knowing that if you're in front of the judge on summary judgment in 3 to 4 months, the judge is no longer required to follow his regulations. So, like, yes, you have the better argument on the regulations, but like you have to factor in the risk that you don't know that what your judge is going to do, because it used to be that judges were bound by regulations,
but not now,
but not anymore. And so the case settled for a few reasons and all of that, but that was definitely something that I had not thought about or been confronted by. Right. It's like because I went into the settlement conference being like, yeah, we have on the regulations,
we're going to win.
It's a no doubt at all.
So
and
interesting.
then the judge is like, yes, the regulation, you are right, but you have no idea what Judge ABC is going to do, because that judge is no longer bound by the federal regs.
It used to be like when you cited the regulations in your brief, you'd be like, these are the regulations, like.
We're on the right side of this issue.
Right.
Right.
Now it's not the case.
Exactly. So I think that's going to be the biggest change, is everybody figuring out what the heck to do, because we don't know, and it's going to turn to each individual judge is going to be their own sort of like kingdom of, okay, this judge,
and it's going to cause judicial shopping.
Yeah, exactly. This judge views an executive professional as meaning this, but this judge means an executive professional is this, and it just depends on who you get assigned to.
And it's not fair, because that's going to lead to inconsistent results, right? For different
employees. So an employer won't know, do I have to make my employees wear a mask or not?
Right.
Because is OSHA going to be applied or not applied? Should I pay this highly compensated employee overtime or not? Or am I going to meet the definitions of the regs? Because the damage is like, if you can't know whether someone's exempt or not, now the risk is that you're going to have to pay them back wages, double damages, and attorney's fees. It's a horrible place to be.
It is, and it's also, we're supposed to have the laws so that we're on notice about what, but now we can't tell people whether or not it is a moving target. It's all up in the air right now without the regs. So that's a little bit scary. It's scary from both sides.
Yeah. And this goes back to the FTC, right? Because what the FTC did is its final rule was a regulation that said that non-competes
which is what
they're supposed to do, and their regulation said non-competes are unenforceable, and a federal judge overruled it, and the judge's decision happened. It happened like a month after the Loper Bright, and so the judge cited it in a footnote. It wasn't really part of her decision, and saying that the rule shouldn't go into effect. But it's one of those where it's like, okay, even if that FTC rule had gone into effect, and we're all going into this thinking like, okay, FTC rule says non-competes are invalid, you could get a federal judge who says, I don't care.
So let's just put that in perspective, right? Congress makes laws, agencies issue policy-making rules and regulations, and then the president can issue an executive order, and that is law. But so my question is, to my scary comment is this: who's going to be in charge? Like when there is inconsistency and when there is a dichotomy about the effective enforcement or a lack of understanding of because there's so many inconsistent rulings, right? Like who's going to be able to make the call?
The final arbiter.
Yeah,
it's going to be this court.
Yeah, it's federal judges with lifetime appointments who are not actually they're not bound to the whims of the public.
That's going to be on a case by case basis. It's going to cause like a smattering of different opinions.
So I hate to say this, but
what happens to the president's power?
What happens is the United Healthcare CEO gets shot because people get fed up because they feel like their will is not being heard, and that's what the outcome is. Anytime that you have a situation, I'm not saying it's right at all. I think it's terrible, but what happens is if you take away
power, he's a hero on social media. Like I have seen the social media sites.
On some social media sites and on other sites, people are calling it out and saying this is wrong. This is not how this is supposed to, you disagree with something, this is not the way to handle it. But you're right. There are enough people that are making him a hero that makes that is making this a discussion, right?
I remember thinking that right after we learned that happened, I remember waiting for the news story to come out about what happened to him or his family member who was denied coverage. Like like you knew I felt
personal.
Yeah, I felt like it was going to be that. That actually wasn't what it was, though.
It kind of was. He came out after the fact that he had some kind of a back surgery that was botched or something.
I was expecting some kind of like Denzel Washington,
John Q.
Oh, my son had cancer but couldn't get the care he needed, and it caused me to.
Wasn't like it's all still kind of up in the air with the back surgery. Like, was that it? Was that not it? Was it
so
just
long ago?
Yeah, it was.
And he was like an Ivy League guy. Like, he was not someone who didn't come from a family with influence and power.
I think it's frustration. I think people are frustrated with like.
That's what I was.
But if you take that example and you apply it to what Gabe's saying about the policy making, who sets the regulations for insurance companies? A lot of that is a federal regulation. A lot of it's ACA, HHS, right?
CMMS,
Right. So it's like if their ability to regulate the basis of a denial of a claim or the approval of a claim or the cost of things. That's what they do, those agencies. If that somehow becomes questionable, then who's in charge? That's the scary part for me. Someone's going to have to make a decision and so it seems like the company's going to be in charge until they get sued and the court tells them otherwise. But they're going to have to be sued in however many different jurisdictions and have multiple.
We still have power as people to vote. And to if they and there is a pendulum swing, right? When people swing, arguably the FTC went too far by saying no non-competes at all. And
they didn't say that. They said no non-competes if your income level is over $150,000 a year. And I know
there were some
things that went too broad
circumstances, but the point that I'm trying to make is that anytime the pendulum swings too far one way and they overcorrect coming back. But like the truth is, if people don't like the way things are going with the Supreme Court, the people are going to speak and they're going to vote out the people who are in power, the administration that is putting those Supreme Court justices in place.
Maybe the turkeys are going to vote for Christmas.
Maybe. But eventually it's probably going to come back. And I don't know. I don't want to be defeatist about it and think that we are without power. We are powerless.
And I only bring it up earlier just because it's in the context of what's happening in 2025. A new administration's coming in. There's going to be a lot of changes to federal agencies that we need to pay attention to. A new general counsel for the NLRB, things like that. But it's going to be one of those, I think, the biggest tests. And we're not going to know it in 25. We're probably not going to know until maybe even after the next election. It's going to be what are federal judges going to do with this power that they've had. Chevron's been the rule of the land since '84,
right.
so
and now it's not
a majority, if not almost every single federal judge, the entire time they've been on the bench, has been under Chevron, and so we have no idea what judges are going to do now with this new power.
Thank you so much for tuning in to the Kathleen Scott podcast. We hope this was fun and informative. We'll catch you on the next one. You can find us online at scottlawteam.com or floridalaborlawyer.com. Thank you for joining.